Back in the record on Edgecomb, appearances remain the same. The jury's not present. The defense is calling their client. We have to discuss, I think, two things, one of which we discussed, or actually both of which we discussed a bit yesterday off the record at the end of the day after I had discharged the jury for the day. The first one, I think, is under 90609, the question of impeachment by evidence of a prior conviction. Mr. Ahmad, I presume that was one of the two things you wanted to discuss, correct?
That's right. The issue is whether the answer should be 1 or 3.
Can you use the mic, please?
Yes.
All right, I'll hear from both sides in terms of the prior convictions. We discussed yesterday, some of this was on the record. The defendant has apparently a CCW, carrying concealed weapon, from 5 or 6 years ago, based on 906.09 of the Wisconsin statutes, based on the factors and the criteria, not to mention common local practice and my practice, that obviously is going to be included. The question is whether the other two offenses are included or not in that calculation. The other two offenses being that the defendant pled guilty last week at the start of the trial to felony bail jumping and misdemeanor bail jumping. I'll hear from both sides, starting with the state, please. Again, I know I heard some of it yesterday, but go ahead briefly.
Your Honor, when we are talking about the number of convictions that apply, we are looking at 906.09. It states under sub 1, for purpose of attacking character for truthfulness, a witness may be asked whether the witness has ever been convicted of a crime and the number of such convictions. When sub 2 goes into the factors that the court can consider in terms of potentially determining its probative value substantially outweighs the danger of unfair prejudice, I don't think any of those would apply in this case. They're not old convictions, they're actually very new. There has been no rehabilitation. The gravity of the crime is disregarding court orders and having a weapon he shouldn't have had. The frequency, having a weapon he shouldn't have had. And considering the fact that his other conviction is a CCW, this would be, again, a weapons-related case. I would note that under State v. Trudeau, that's Trudeau, that is, if I'm not mistaken, 458 Northwest 2nd, 383. In that case, the court looked as to whether or not a conviction for which someone has pled guilty to but has not yet been sentenced would count under the statute. And in Trudeau, they determined that it did. Now, I want to be very clear, the facts are a little bit different in Trudeau because it was a different case to which he had pled guilty while going to trial on the armed robbery, but I think it still remains the same. This defendant has pled guilty to 2 counts. He is convicted of those 2 counts under the Trudeau reasoning, and when he testifies, he will have had and does stand previously convicted of 3 crimes. The legislature has let us know that individuals that have have convictions, that can be considered by a jury for purposes of credibility. He has 3 convictions. His number should be 3.
I read the Trudeau case, and counsel is correct that basically the situation there was the client had another case, had entered a plea, but wasn't sentenced, and that was the issue on appeal. And the court did say that that was countable, even though he hadn't been sentenced, given that he had pled and there was a judgment of conviction. But that was a separate case. Here we have a different situation, and I think ultimately the court has the discretion to do the proper balancing under the factors. The court had also asked us to look at what other jurisdictions do, what the federal rules are on this, and there's a lot of variation between the states and the federal rules. I think, however, one major factor is whether this bears on, dishonesty is one factor that I think most courts consider. The age of it, I mean, obviously this is extremely recent, but it is of the same offense. And had he not pled, this wouldn't have been coming in at trial. Rather, he'd be presented with the bail jumping charges, and the jury would have to reach a conclusion on that, whether he was guilty or innocent of that charge as well. But then the answer would have clearly been one. So knowing that Mr. Edgecomb has already entered his plea ahead of time, and this wasn't part of any plea offer, I mean, I think the court should also consider the proper balancing as to, if the answer is 3, I think the defense should be allowed to just simply in 1 or 2 questions say, well, Mr. Edgecomb, 2 of those things were for, bail jumping charges, or 2 of those priors are for bail jumping charges that were charged along with this case, and without getting into further detail or opening the door as to what the previous priors. That's one way to deal with this. Or to do it cleaner, we would just say he still has 1 prior, Judge, and I think, there's a discretionary.
Mentioning the bail jumping in front of the jury would be, I thought, exactly what was trying to be avoided by him entering pleas to those 2 charges. So if you say the words bail jumping to the jury, that's not a positive. Let me hear from the state, and then I'll make my ruling.
Judge, the only reason I'm saying that is because the state has said they will cross-examine on that, and I don't know what the clear parameters of them being able to cross on the bail jumping is. I think from what I remember counsel saying, he would say, well, you weren't supposed to have a firearm, or you were restricted from having a firearm. The question is, does the inquiry stop there?
I wasn't going to ask anything more than that, and you actually already introduced that to the jury in your opening statement. So that's already in front of the jury. You told them that he had 2 court orders that prohibited him from having a firearm. I wasn't going to go into the fact that he had
There
a
was an officer who also elicited that. I know you didn't ask the question.
We didn't ask the question, and we moved on immediately.
Mr. Ebner, under 906.09. Anything else?
I think it should be 3. If the defense wants to go ahead and introduce what they tried to keep out, they can do that. I guess that would be a tactical decision. I think they should have a conversation with the client before they do that, though.
I would hope it would be a tactical decision. All right, under 906.09. Generally, as the lawyers know, for the purpose of attacking, and I'm paraphrasing the statute, for the purpose of attacking the character for truthfulness, a witness may be asked whether the witness has ever been convicted of a crime or adjudicated delinquent and the number of convictions. Then under subsection 2, exclusion, evidence of a conviction of a crime may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Factors for the court to consider include, again, I'm paraphrasing, the lapse of time since the conviction, the rehabilitation or pardon, if anything like that applies, the gravity of the crime, the involvement of dishonesty or false statement in the crime, frequency of convictions, and any other relevant factors. Going back briefly, can the state just put on the record the underlying basis for the felony bail jumping and the underlying basis, again, for the misdemeanor bail jumping, which the defendant did plead guilty to last week, please?
Yes, Your Honor, the misdemeanor bail jumping was because in Waukesha County case 20 CM 458, in which the defendant was out on bail for 6 misdemeanor counts, operating while intoxicated, causing injury, carrying a concealed weapon, disorderly conduct, resisting or obstructing an officer, operating a firearm while intoxicated, and causing injury while operating with a prohibited blood alcohol level in excess of 0.15. He was released on bail with the condition of bail that he not have any dangerous weapons or firearms. The defendant pled guilty to possessing the firearm on the date in question in violation of that misdemeanor bail from Waukesha. The defendant on the felony bail had been charged in Milwaukee County case 19.
He pled guilty on the Waukesha misdemeanor?
He pled guilty to the misdemeanor bail jumping. He hasn't pled guilty to the Waukesha case yet. That was pending. That's still pending. They were, at one point, they were going to do an NGI, then they withdrew it. I don't know what's going on out there. In Milwaukee County, 19 CF 5517, the defendant was charged with substantial battery, disorderly conduct, and actually 2 counts of disorderly conduct. The defendant was released on bail on that case with a condition of bail that he not possess any firearms. The defendant pled guilty to that case for having the firearm in violation of that felony order at the time of this offense. We've talked about it before, but just so the record is clear, the victim in that case was Ruby Mizell, and she did not appear at court or did not cooperate, and the case was dismissed.
All right. To the question of has Mr. Edgecomb been convicted of a prior crime? Based on my evaluation of 906.09, looking at the lapse of time of the convictions, again, the one carrying concealed weapon is 5 or 6 years ago. The other 2 matters were last week. Under Trudeau, obviously the defendant has been convicted of those 2 matters. I asked the state specifically to make a record on the misdemeanor bail jumping because I considered, though I'm rejecting my thought, I considered that it might be de minimis enough to not count it. But it's a misdemeanor that was pending with 6 separate counts. As misdemeanors go, a more serious list of misdemeanors, I think looking at the appropriate balancing test, looking at all the factors under 906.09, the appropriate answer is 3. So, Mr. Edgecomb, if you're asked by your attorney or the state, have you ever been convicted of a crime, you're to answer yes. You understand that?
Yes, Your Honor.
And the second question will be how many times, to which you're to answer 3. You understand?
Yes, Your Honor.
Fine. What was the other issue again, gentlemen?
Well, there's actually 2 now, Your Honor, and I apologize. The next one was, the court had asked if I could send the case that I had sent to defense counsel over the weekend. It did involve whether or not an assertion made by the defense in a motion as to what the defendant in fact would testify to. If the defendant testifies contrary to their assertion as to what his testimony would be, whether or not that assertion by the defense would qualify as a statement.
Well, let me jump in. We discussed some of this off the record yesterday.
Yeah.
Should we not wait and see what the testimony is?
Sure, that was the second issue.
Right,
And
moot point. The other issue, I think, was that there was a question that the state asked. You put this on the record yesterday. We discussed it off the record. I basically made my ruling off the record and told the lawyers what to expect. But when the defendant was apparently allegedly picked up or stopped in Kentucky, he made some comment. The state can correct me. It's something along the lines of, oh, what happened in Milwaukee? Is that correct?
He said what happened in Milwaukee. That's correct. When they identify themselves as Milwaukee police detectives and state that they would like to, that they're there to talk to him about what happened in Milwaukee, he stated what happened in Milwaukee.
And this was, correct me if I'm wrong, based on our conversations yesterday, the Milwaukee detectives come down to Kentucky. They, again, the state can correct me if I'm wrong, walk into, I presume, a room or an interrogation room or a seating area and say they're here to discuss what happened in Milwaukee. Can you just clarify for the record?
Yes, Your Honor. The detectives drive down to Kentucky. They go to meet with the defendant. They begin talking to him and asking him a number of questions to make certain that he understands what they're talking about. Like, is he on medication? Does he understand them? Does he speak English? Is he...
The basic pedigree background questions?
Yes, and the defendant says he doesn't even know who they are, and they say, we'll get to that. We just want to make sure you understand what we're saying. When the defendant indicates that he does understand what they're saying, the detective, I believe Kirkvold, states, well, we're City of Milwaukee police detectives, and we're here to speak to you about what happened in Milwaukee. The defendant then responds with what happened in Milwaukee.
The state wants to use that and cross on that, correct?
Correct.
Counsel for the defense, Mr. Ahmad.
Judge, we made our objection to that earlier, I believe, but again, that statement was prior to the Miranda warnings. I know what the state's position is regarding whether there's going to be any, whether they have any testimony on rebuttal, but I just think the point regarding consciousness of guilt has been made in this case. It's not disputed. This is just becoming cumulative evidence.
Well, hang on. There's been a lot of cumulative evidence. The video's been played, I think, 700 times by both sides. I've been encouraging both sides, starting yesterday, to move it along. But there's not been a lot of evidence of consciousness of guilt. I'm allowing the state to cross on that issue. Obviously, as I've ruled previously, consciousness of guilt is admissible in this case, as is the evidence, alleged evidence relative to flight. If there's any evidence related to concealment, consciousness of guilt is all relevant to this case. The defendant allegedly, basically the defense admitted this at their opening statement, fled the state, was on the run, or at least not in Milwaukee, for 6 or 7 months. The state can cross-examine on that, ask the defendant about that. Maybe there's an explanation, maybe there's not. Both sides can ask about it. I think that clarifies everything. I'm ready to bring the jury in.
The defense has just shown me for the first time 3 photos that they plan on introducing. They're photos of the defendant with his children. I don't believe that there's any relevance to them. I would ask the court to take a look at them and make a ruling.
Fine, hand them to my clerk, please. All right, I've been shown 3 photographs, one of what purports to be the defendant with a child at basically a T-ball game or T-ball situation, one with the defendant with another child, it may be his child, in sort of a swimming lesson type situation, and another that I don't know if this is a defendant or not because it's a back. It literally is it's shot from behind the defendant or behind the person who's standing with 2 children at some sort of rally or protest. Mr. Ahmad, how are those relevant?
Okay, so first, Judge, this basic background information, I think the defendant has a right to talk about his, generally speaking, his family, just some basic information about himself like a lot of witnesses have been doing. Number 2, the state introduced 2 photos that don't show him in the most favorable light. They're mugshots, where he's not really well groomed. And
well, first of all, counsel, the one photo that we discussed was literally on the screen for 2 seconds, and it was directly relevant to this case. Yes, you and or the state can ask a few basic background questions. Where do you live? Where'd you grow up? I think it's apparent he's not been working for a while, but what's your occupation? Those kind of things. Candidly, Mr. Ahmad, never in my life have I seen photos like this shown to a witness on basic background questions.
Number 3, Judge, part of his story that night is that he was planning on spending time that evening with his daughter, daddy-daughter date night. I'm sure the court's heard that phrase. So there's a photo there involving his daughter. And there's one more photo that would go to his state of mind around the time. The state has put in consciousness of guilt evidence. I think we're allowed to rebut that to talk about what was going on during the summer of 2020 leading up to September 22nd, 2020. And as the court referred to it, it was a picture of a protest. That protest was a BLM protest, and there's a lot of events that happened in the summer of 2020 that, from our client's point of view, subjectively, he was in fear of what had occurred, a fear of the system, of police, things like that. And I think he should be allowed to talk about that. And that's what the relevance of that picture is. That's the 3rd picture in the stack of 3.
Judge, the picture doesn't even
Right, the picture doesn't demonstrate any of that. It demonstrates what, again, purports to be, I don't even know if it is, but I'll assume for now that it's the defendant with his back to the camera with two children that are probably in the range of ages 3 and 5 or 3 and 6, somewhere in that age range, observing a march or protest or it looks like a bunch of bicyclists and walkers.
There's a sign that says Black Lives Matter on it, Judge. He can obviously authenticate that that's him. I mean, he should be able to recognize what he looks like, even if it's from behind.
Understood, but what does the photo matter? He can testify. If that's what his mind says to leaving, what you're trying to do is you're attempting to show pictures of his kids in an attempt to make the jury be prejudiced against convicting him. That's the whole point of this. We never showed any pictures of the victim's family. We never showed any pictures of the victim's wife with them. We showed one photo of the victim for purposes of identification. That's it. You want to show a picture of the defendant dressed nice? I don't care. But you start trying to put in pictures of his family, the whole purpose of that is to have a prejudicial effect. There is no other relevance.
That's absolutely correct. Mr. Mod, you know that's the reason, and you don't have to say it out loud, but of course that's the reason. The reason is to make the jury not want to convict him because he's a nice guy, because he worked with his kids, because he may have coached T-ball. That may all be correct, and I'll even allow you to ask questions about it. But the state's correct. For me to allow this, the state would then ask on rebuttal to now bring in photos of Mr. Cleereman with his wife, or photos of Mr. Cleereman with his child, or photos of Mr. Cleereman at a baseball game or swimming with somebody. It's not relevant. The questions about these issues can be asked within some reasonable degree of relevance, but the photos are not appropriate. Never in my life have I allowed a photo in a situation like this. Never in any case. There's not a basis for it. I'm sustaining the objection. Let's bring the jury in. The defendant is on the stand. I will make a record that multiple times over the last week, I have intentionally had witnesses sitting on the stand or ready to testify, meaning not walking up in front of the jury. Obviously, as we know, but it has clearly been kept away from the jury, the defendant is in custody. He's seated on the witness stand. He's in street clothes. He's in a suit. We'll proceed in the same fashion. I'm bringing the jury in. I'd like this examination to hopefully conclude this morning. That's an hour and a half total for the two of you, for both sides, I should say. But we'll bring the jury in. Everyone else can remain seated.